Curry, I guess you're ready to proceed for the state, right? Did we lose Ms. Curry again?
I think she's muted.
What is it?
I'm here. We're ready.
Okay, great.
Okay.
Okay.
I'm not a very good operator on this.
Well, I'm not either. So we just have to get, I had my grandson help set this up and didn't get set up quite. Hi, Mr. Cox. I can't hear you, but I can see Mr. Cox. Mr. Cox was the assistant district attorney assigned to this case, and then when the pretrial hearings and so forth. And I'm not sure what the earlier date was when we attempted to address the issue of expunction, but I guess, Ms. Brumbaugh, it's your motion. So, but as far as I'm concerned, the testimony that I heard at the earlier hearing doesn't necessarily have to be repeated. I do recognize and am aware as the assigned judge in the pending indictment against Mr. Beall and the proceedings incident of that, including its ultimate dismissal by state's motion. So with that understanding, go ahead, ma'am.
Your Honor, we're here because the last time we received notification at some point in time that the code hadn't been complied with inadvertently or whatever the reason was, and notice was not sent out to the different agencies, including Van Zandt County Sheriff's Department or DPS. It was a number of the ones that were listed in our motion. Since then, my understanding is in checking with the district clerk's office is notice was sent to everybody that was listed in the motion. Since then, yesterday, DPS filed an objection and a general denial to the petition for expunction, alleging that we have invalid basis for it. We went through the testimony pretty substantively last time with Mr. Beall, and also the court took judicial notice of the conversations that they were at privy to during the course of the criminal proceeding.
Well, given the fact that neither Mr. Cox was there, in fact, before that hearing, Mr. Cox, by some email of which the coordinator has been asked to produce copies of, indicated two things. First, that the state had no objection to it, and second, that he had other things, other official business he needed to tend to, and would I excuse him from that proceeding, which in fact I did. All of that occurred before the case was literally called. But with that understanding, go ahead, ma'am.
Yes, Your Honor. Since then, because the DPS and them weren't provided notice, they have the right to object underneath the code, which they did that. So because of their objection, we would have to put on just a little bit more of additional testimony, that being either by Mr. Cox or Mr. Curry, excuse me, Mrs. Curry, I'm sorry, Tonda, by Mr. Cox or Mrs. Curry, indicating as the basis whether it was due to the inconsistent statements and possible false information, and showing lack of probable cause as to that existed at the time the case was dismissed. So I would technically need to call them, or they can give a statement the court can recognize on their own as testimony with regard to that. And then we would be back in the same position that we were at the original proceeding after having everybody been given the proper notice in this case.
And that's correct, Judge. The state of Texas, the Van Zandt County District Attorney's Office has the authority to represent the state of Texas in this, and we do not object to the expunction. The problem before was simply that after the hearing, it was discovered that notice hadn't been sent, and therefore the agencies weren't required to comply with the court's order. So Mr. Beall wasn't getting the protection that he thought he would be getting after the court signed the order. Now everybody has been served as they're supposed to. DPS has filed a response, but I don't see them here today. I can see the courtroom. I don't see them there. So as far as I'm concerned, we are prepared to go forward, and on behalf of the state of Texas, we do not object to this.
I would assume, given this kind of proceeding being all handled remotely, there's not physically a bailiff in the attendance, is there?
There is, Judge. Would you like for us to have a call?
I would, Sheriff, would you mind calling the Texas Department of Public Safety and an audible voice as any other person or entity would be summoned at the door? Once that's done, then I think I'll be in a position to do some ruling.
And Your Honor,
Is there a new, I'm sorry, Ms. Brumlow, you were trying to say something.
I do apologize, Your Honor. I didn't mean to interrupt you. I would like to ask Mrs. Curry just a brief question. If I could get this on the record so that way we can clarify it and make sure there is no additional objections from this point forward so we can withstand any type of appellate review if it becomes necessary.
Okay, Sheriff, did you get any response by the Department of Public Safety?
No.
Okay, the audio is not real clear, but I heard enough to know that having been called at the door after notice, the department, although having filed an answer, in fact, has not appeared, nor has anyone appearing, any counsel appearing for it, other than obviously the district attorney for Van Zandt County, who has criminal jurisdiction. Now, thank you, Sheriff. All right. You said, Ms. Brumlow, you need some questions to ask of either Ms. Curry or Mr. Cox. Go ahead.
This is Ms. Curry. It'll be really quickly. Mrs. Curry, after reviewing evidence in this case and the criminal proceeding and going back and forth with the evidence and the different things that were presented from the experts and whatnot, probable cause no longer existed to support the charge of sexual assault in which is a second-degree felony against David Lynn Beall at the time of dismissal. Is that correct?
That is correct at the time of dismissal. There was probable cause at the time of indictment. However, additional information came forward, and at the time of dismissal, there was no longer a basis for proceeding.
Okay. And we had experts look at this case and whatnot too, that you were able to review to make sure you made the appropriate decision on behalf of the state of Texas with regard to dismissal in this case based upon lack of probable cause at the time of dismissal. Is that correct?
Yes, ma'am.
I have no further questions for Ms. Curry at this time.
Ms. Curry, do you need to ask yourself anything?
No, Your Honor. Thank you.
Ms. Brumlow, anything further?
I do not have anything further. I would just ask the court to take judicial notice of the proceedings on 5/11 of 2020 and incorporate that testimony as they said they would do into the record for today as well too.
Okay, I will take judicial notice, and in the event there's any appellate review of the proceeding or the actions of the trial court involving the question of expunction in this proceeding, then I'm taking notice of and incorporating the testimony and the proceeding previously had May the 11th of this year. Also, I'm taking part of the record in this proceeding will be the email exchange by and between the court coordinator, Mr. Cox, myself, although I don't think Mr. Cox and I actually sent anything to each other, but we ended up being copied because the court coordinator was the intermediary. With that understanding is that I assume all evidence that anybody needs to present is now in.
Yes, Your Honor, that would be the case.
All right.
Yes, Judge.
Sir?
I said yes, Your Honor.
Oh, yeah, well, yes, ma'am. Well, Miss Curry, your face is not on it, and Mr. Beall moved, and I thought he was the one saying something. I apologize. That's why I said, sir. Okay, I'll close evidence. The motion or the relief for expunction is granted, and I will sign a new order. Ms. Brumlow, does the coordinator have such an order?
They should have the original order that was submitted that had blanks in it. If for some reason you need a new one, we'll be more than happy to send one to you, either the court coordinator or directly, however you prefer, Your Honor.
Okay, if you would, after Ms. Curry's had a chance to look at it, if you would just send it directly to me, because what I do is I'll end up printing it, sign it, and then faxing it back, because I'm still one of these old timers that believe in ink on paper. I want the real world, not a virtual one that I live in. So unless there's anything further, I'm about to conclude this proceeding.
I have nothing further, Your Honor.
Thank you, Judge.
No, thank you.
Thank you. Thank you.
Nice to see Mr. Cox, you again. Nice to talk to Ms. Curry again. Good luck, Mr. Beall. This
Thank
proceeding is now closed.
Thank you, Your Honor.
Yes, ma'am.